Hello, and welcome to another presentation. In this presentation, I'm going to discuss what an affidavit is and give you some general guidelines on how to write one and what to do with it. Many people are trying to proceed with court and get ahead, and they don't know what to do. Hopefully this will help you. Here's how you write an affidavit. You begin with the title. This is a clear title, such as affidavit of, and you put your name. Sometimes you include the information for the court. Then the statement, you identify yourself with your name, age, occupation, and current address. This allows somebody who wishes to question the authenticity or the points made within that affidavit to give them a place to send their correspondence to. And no, you can't ignore it. They send you some paperwork, answer the darn thing. And then it's the statement of truth, which affirms the information that you provided is true to the best of your knowledge and based on your information. You can't put any hearsay evidence or Sally told me whatever last Thursday at the bus stop. That stuff doesn't fly. It has to be something that you know, you've experienced, and you've dealt with. Not something somebody else dealt with that told you about it 3 weeks ago. The body presents the facts in numbered paragraphs, with each paragraph containing one single fact. Don't write a paragraph with 18 facts in it and expect it to fly, because it's not going to happen. Then you have a closing statement of truth, reaffirming the information you provided above is correct. There is no limit on how many points you can put in an affidavit. It's not limited to what's on one page either. You can write an affidavit with 10 points, you can write it with 100 points, provided each one of those points is factual and true. Now, in some cases, you may make a reference to a point. Just say, for example, my car has a scratch on the front fender after the neighbor backed into it with his lawnmower. Proof attached, Exhibit A. And you would turn around and then take a picture and attach it as part of your affidavit as Exhibit A and show the picture where the fender of your vehicle that now has a scratch in it. You may also have a picture showing before the neighbor backed into it, and you may in fact show a picture of the neighbor's tractor where it hit your vehicle. That's one example of how you would include substantiating information to prove your point. It's usually done through an exhibit. Then you take your affidavit and you sign it and get it notarized in front of somebody that has the legal authority to do that. Usually a notary republic or a lawyer or a commissioner of oaths. And in some cases, or in most cases, you can get the local court to do it for you. Don't sign the document prior to going to court, however. They have to see your ID. You have to affirm that the information on here is correct, and then they'll ask for your ID. Ask yes, you affirm that everything here is correct, and you confirm that. Then they'll witness your signature, and that's it. They charge you a fee for doing this. They're not supposed to under the Notary Act, but they do, so just play the game in order to get this fiasco over with, right? Now, what I tell people to do is write up your affidavit if you're going to make a claim to the best of your ability. And you may forget a point or two, so don't be in a hurry to rush down to the local courthouse or wherever to get the thing sworn. Write it out, think about it. Maybe you want to restructure some sentences, make it sound better. Maybe you remember a point that you didn't include previously. And when you're happy with what you're going to submit, then and only then would I go through to get that thing sworn. Now, once you have this statement of facts down, which is in chronological order, meaning in the order in which it happened, then I would write up my statement of claim. Okay, that's if I'm the plaintiff. So if I'm the plaintiff, I'm the one trying to charge somebody for something. Now once I have that done, because I know the rules of court indicate that the other side is not obligated to respond to me until after I provide my evidence or my disclosure, I would then go down to the court. I would be prepared to pay them a fee to open a file, usually a civil claim, and go from there. And they'll generally ask you what your claim is, how much it's for, what you're looking for in the way of what do you want the court to do. Once you get that information in front of them, they'll charge you a fee, they'll sign you a number, and you will then take your documents, which would be your statement of claim and your affidavit, and you would put the court file number in the upper corner. It would be on the upper right-hand corner in Ontario and in the UK. Now, when you do that, you can then take those documents, and I would bring 4 copies with me of each. The court may keep one of those copies right off the hop. You'll only have 3 left, or they may give it back to you and just record the file number. Each court operates slightly different. Once you serve the opposing party those documents, under normal circumstances, they will give that to their lawyer, and then the lawyer will request disclosure. But the lawyer can sit on it for a month, 2 months, 3 months before they request disclosure, and you've given them the opportunity to figure out some way to get out of this mess that they're now in on behalf of their client. However, if you turn around and serve them with the affidavit, which is the documents we've written here, and the statement of claim to whatever the party is, the clock is already ticking, and they have 30 days to answer it. They would have slightly more than that if they're an international issue in another country. And then the party that you've served, whoever they are, they better find a lawyer because the clock is ticking, and after 30 days you can motion the court for summary judgment. This is how I bypass some of the delay. Because court cases I know of that have gone through the courts, some of them I've dealt with 3 or 4 court cases, and the one court case that I didn't deal with is still sitting in the court, not moving anywhere, because the other side decided not to ask for disclosure. So if I'm taking you to court as an example, and I don't know who your lawyer is, and you get the document and I don't give disclosure at the start, you may take 6 months to find a lawyer, and he might take another 3 months to turn around and get a hold of me and ask me for disclosure. I've wasted 9 months. Why not turn around and serve you disclosure, and that's your problem now? That's my way of looking at it anyway. When you write these affidavits, you always write them in the first person, meaning I saw, I heard, I witnessed. Don't give somebody else's information like Johnny told me. It's based on first-hand knowledge. Otherwise, it's hearsay evidence and it's inadmissible. Be concise and clear. Keep your statements short and to the point and as accurate as possible. Stick to the facts. Don't include your emotions, the fact that you think the guy's a pinhead or anything. That doesn't matter. Okay? Only include information that you personally witnessed or experienced and you can prove. Okay? The court doesn't care about your opinion or what you think you know. It cares about what you can prove on paper. Be specific. Provide exact dates, times, and amounts when possible. Include your evidence to back that up, such as photographs, receipts, as your exhibits. Organize your information chronologically. Present the information in the order it happened. Don't bounce around and start from the start of the story, then the middle, then the end, and then back to the start, and then back to the end, and back to the middle. Don't do that. Use proper formatting. In most cases, it's Times New Roman font with 1.5 spacing, and they want 12-point font or slightly larger. That's so they can read it. Okay, if you make it really tiny, the courts will throw it out or won't even accept it. Avoid opinions and assumptions. Stick to facts and factual information. Avoid making any judgments on somebody. If you are writing an affidavit, you can use Form N285. If you're in the UK, you can look that up. Or if you're in Ontario, it's Form 14A. There are other forms of affidavits. When you serve a document, you would fill out an affidavit of service. That's a different protocol, different thing for a different event at some point, because that's not the purpose of this here short explanation. So now, anybody that wants to file a claim can look these 2 things up, and it'll give you general guidelines. What I generally was trying to do when I was copying documents when I was learning this stuff 30 years ago is I would pull up a document and see what some lawyer filed, and then I would modify the daylights out of it so it matched what I was trying to do. But as long as it followed the same procedure and protocol, if it was accepted from when the lawyer filed it, it should certainly be accepted when you file it. Don't be the stupid one and try to generate your own court form and send it in there and expect them to file it. Don't put thumb stamps, ink prints, footprints, teeth marks, flowers and whatever other crap on there, barcodes, weird crap like that, because there has been a case called Meads versus Meads, and as soon as the judge sees any of that stuff, they will automatically dismiss your file. They'll label you as one of those free man on the land people, and you've already lost the war before you even got out into the battlefield. Don't do it. Simple as that. If you have any other topics and would like me to cover them, please send me an email with the topic, and also if you want to be added to my mailing list. I have a mailing list of people which were primarily on that list for a potential tour that went across the UK. However, due to the lack of response in significant numbers in each location, that's been postponed. Please note that I don't share your emails. If somebody wants to get a hold of you, that's their problem. I'm not your secretary, and I won't be forwarding your email to them or anything else. Now, if it's important, I may contact you and say, hey, Joe Blow's trying to get a hold of you. Here's their email. What you do with it's up to you. I hope you found this information useful, and I look forward to bringing you additional information as the need and time permits. Thank you, and have a great day.